Good afternoon, everyone. Welcome to the Joint Standing Committee on the Judiciary. Thanks for your patience with our slightly later than expected start, but we're really happy to be here. Representative Sinclair, would you like to begin introductions?
Good afternoon and welcome. My name is David Sinclair. I'm here for the people of House District 50, the city of Bath.
Good afternoon, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good afternoon, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good afternoon. I'm Danny O'Halloran, and I proudly represent District 20, which is the majority of the industrious city of Brewer.
Good afternoon and welcome, everyone. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Good afternoon. I'm Mark Babin. I represent House District 3, Northeast Aroostook County.
Good afternoon. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Welcome, everyone. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee.
And I'm Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, some of Scarborough, and I serve as the Senate Chair. And Eli, are we doing a language review first? Great. We're joined by our committee clerk, Eli Murphy. Legislative analyst Eli Murphy, legislative analyst Janet Stocco, and committee clerk Susan Pinette. And Eli, I'll turn it over to you.
Great. You should have in front of you LD 1647. This is an act to amend the Humane Human Rights Act to provide additional remedies for educational discrimination. I apologize. The copy in front of you does not have the members of the report. This was a majority committee amendment in which Senator Carney, Representatives Kuhn, Sinclair, Pugh, O'Halloran, Lee, and Sato, and then also Senator Talbot Ross are members of. The changes to this amendment you see there, this is striking and replacing the section 2, which discusses and adds that language in that subparagraph B, talking about the cap to the compensatory damages at $100,000. And you will also see the addition of a fiscal note, which was new since the time of the voting of this amendment.
Committee members, any concerns with this? Okay, I think it's good to go. Thank you.
Great. Thank you so much. I think we'll now transition to FOAs in, I'm not sure which order we have all three. Yeah.
Eli, do you have the numbers of the FOA reviews that we're doing? Okay.
So the three public records exception reviews we have are LD 2025 is from the Marine Resources Committee. LD 2201 and 2202 are from the Healthcare Insurance and Financial Services Committee.
All right, and I'm seeing we have people here for, at least for 2025. Should we start with that one?
Sure. So LD 2025. Is an act to create a limited purpose license for aquaculture, nursery, and husbandry activities, and to clarify the aquaculture lease amendment process. And we have Representative Hepler here and someone also from the department, and this was a Department of Marine Resources bill. So I could give you the background, or I look for your direction on how to move forward.
Sure. Feel free to orient us. Thank you.
Certainly. So This is a unanimous report out of the Marine Resources Committee. Again, LD 2025 is an act to create a limited purpose license for aquaculture, nursery and husbandry activities and to clarify the aquaculture lease amendment process. And this is a unanimous committee amendment. You don't have the original bill with you in your packet because the original bill doesn't have anything about confidentiality in it. All of the provisions about the information that's collected and then that becomes confidential was added through the amendment. So what you have in front of you is what you need for purposes of this review. But what the bill does, just as general background, is it establishes a limited purpose license for aquaculture, nursery and husbandry activities and a process for amending certain types of aquaculture leases to include new species, gear, equipment, and structure. So that's the general bill. The part before you is the amendment adds language that authorizes the Department of Marine Resources to inspect and sample aquaculture lease sites in certain circumstances and provides that sample results are confidential with limited exceptions. And so if we want to look at the amendment, which you should have as the attachment to your memo, we're going to be looking at page 3 of the amendment, which is really where all of the meat of the FOA review exists. So this is an amendment to the bill that will add a new section in Title 12, which is section 6085-B, right to inspect and sample. So it says whenever a lease has been issued and then it has cross references to different types of aquaculture leases and licenses. So there are several different types, but that's what all the cross references are. I have all of the underlying statutes if you want them, but that's what they are. So whenever there's a lease or a license, then the Commissioner of Marine Resources or the agents of the Commissioner are required to be able to access the lease or license area for the purpose of inspection or collection of samples. Samples may only be collected when the Commissioner or their agents has identified a possible risk to public health or animal health or the health of other marine organisms. And they have to notify the lease or license holder at least 24 hours in advance of collecting any samples. And they must collect as small of a sample size as possible. And they have to also provide the results of the testing to the lease or license holder immediately after they become available. And then if we look down into section 8 of the amendment, which is enacting new Title 12, section 6085-C, it's going to say, as a general rule, the results of the testing of these samples would be confidential with the following exceptions. The Department of Marine Resources would be able to disclose the results of any sample when the department determines that the release is necessary to protect public health, to the Bureau of Marine Patrol when the results are necessary for enforcement purposes, and if the department is going to rely on the results of a sample testing to consider a renewal application of a lease or a license or to initiate revocation, they're going to have to make it public as part of that licensing process. So that is the crux of what you're reviewing here today. So as the memo summarizes, again, it says that these sample testings are confidential, except again, when it's necessary to protect public health, then the department can release it when they're going to rely on it for any licensing activity or when it's necessary for the Marine Patrol for enforcement purposes. And then they copied for you the part I showed you from the amendment, but I just wanted to orient you to the fact that it's just in the amendment. It wasn't in the original bill. So you are really seeing all of the things you need to see if you look just at the memo.
So let's just pause here for a moment and see if there are questions on what Janet has established. Representative Sinclair.
Thank you, Madam Chair. Janet, I want to make sure I'm understanding you, and in particular, understanding what the amendment seeks to do. I'm looking at section 7 on page 3.
Yep.
In what would become section 6085-B, looking about 6 lines from the bottom of that paragraph. At the line that it doesn't start with, but shortly after one word, it starts with the commissioner or the commissioner's agent shall provide, you said results of the testing.
And
what we
that-
have before us says request. Which one?
I think
is
it will be results.
Okay, so that's just a typo.
Yes, I think so.
Thank you.
6085B.
You have it for you. Yep. And Representative Hepler has a more final looking version and that word is results.
Yes.
Thank you for catching that. If you ever get tired of your job, we have a job for you downstairs.
Welcome, Representative Hepler. I just had a question. Can you, or if maybe if there's someone else in the room, but if you could answer, what is the purpose for keeping that information confidential? What is the purpose for keeping that information confidential?
I'm going to phone a friend.
Okay.
And if you look in the memo,
Mhm.
in paragraph A, I think is the crux of the argument that disclosing the records could have unintended consequences, depending on the sample results. And we do have somebody from the department, and this is the department bill, so they can explain this much better than I can. But there are some concerns that even the existence of the fact that testing occurred might make some people nervous, perhaps unwarrantedly, I think is.
What paragraph were you referring to? I
This
couldn't
is
hear you.
in the, under paragraph E in the memo's statutory criteria review.
Balancing the effect of public disclosure on business competition against public interest. Yeah.
Okay.
That's, I think, where the crux of what I saw in the memo focused on. But definitely we should probably ask the department.
Okay. Before you go, are there any questions for Representative Hepler? Yes, Representative Henderson.
Thank you, Madam Chair. These leases and good afternoon, Representative.
Hi.
Hepler. Hi. These leases and licenses, they're being provided to private landowners, private property owners, or it's public?
Aquaculture.
Aquaculture.
Yeah, so oyster farmers, they're generally on the water.
But all privately owned, or is it?
Yes.
It's public. Is there any of it that's publicly owned? Like owned or run by the state, whether it be nurseries or?
I don't know. I mean, I think towns can have, I think I'm gonna.
Why don't,
Yeah,
yeah,
that's fair.
that's fine.
Yeah.
Let's do that. Thank you.
Thank you.
Hi, I'm
Hi.
Cole Canwit. I am the Director of the Bureau of Public Health and Aquaculture at the Maine Department of Marine Resources.
Great.
And I could start with this question if you'd like.
Sure. Thank you.
The marine waters are owned by public trust, so it's really the property of all Mainers. The state has jurisdiction to lease or license aquaculture in marine waters. And so there is a lease granted if somebody applies for a standard aquaculture lease, they can get up to 20 years for a certain amount of acreage. And then they're able to have private property like their gear and their oysters on that lease. But it's a lease held, by the company or the individual.
The lease is held by the individual, which is essentially a private company, but it's on public land. And that's why it's public land, like public waters, right?
Leased public waters. Yes.
Leased public
Yes.
waters.
Yeah.
Okay, thank you.
And then can you talk a little bit about what I was asking about the need for keeping that information confidential?
Yeah, I think I was at the public hearing and the work session, and industry members brought up some concerns about the department sampling and unintended consequences of those sample results being accessed through Freedom of Information Act. We tried to narrow when we would do sampling to try and address some of those concerns and also provide that 24 hours of notification to the lease or license holders so that they would know that we were going to come to sample. But if we're out inspecting sites, which we're required to do every year, and we're out there on the site and we see something that doesn't look right. So I don't know how experienced you guys are with oysters, but they're supposed to, if you pull them out of the water, they should close both their shells. And sometimes you can see them doing a thing called gaping, where they just kind of lay there with their two shells open a little bit, and they look like they're in distress. And that could be for a variety of reasons. It could be because they have a type of disease that only impacts the oysters. It could be because they're being impacted by paralytic shellfish poisoning, which is actually a public health concern, because then if those oysters are harvested and consumed, people can get very sick and potentially die. So when we see something like that, we would want to take a sample and we agreed that we would wait 24 hours, notify the leaseholder so they could be there if they wanted to when we took the sample, and then we would process the samples. In the case of paralytic shellfish poisoning, where that's a legitimate public health concern, we wouldn't want to protect it from the FOA laws. But in a case where we're sampling something, say they're gaping and it turns out to be an animal disease that doesn't have any kind of implication for humans or other organisms, it's kind of a non-issue. It might affect the oysters, but it's an issue for that farmer potentially because of their crop, but maybe not for the public or for anybody else. Then that would be protected because people can, I'm sure you guys are well aware, people can take information like that and spin it in a way that can sound like something dangerous when it's not actually dangerous, and just sort of skip over the details about this is an animal only disease and not a public disease or something like that. And so that's where, that's an example of where that information could be protected from being stolen.
Representative Lee?
So I'm looking at 6085B, and prior to doing the sampling, it looks to me like the commissioner has to provide notice about why the sample's being taken, which I guess would probably be, we have suspicion that there's something wrong.
Yes.
That notice, though, doesn't seem to be confidential. So I'm just curious whether that was discussed and what the intention was of that policy.
I don't recall that being discussed in committee. And I think when we wrote this, we envisioned we'd call them and say, hey, here's what we noticed on your site, and we're going to come out, within 24 hours, although that doesn't leave a paper trail that we met our obligation. So it's a valid point.
Other questions? Representative Henderson?
Thank you, Madam Chair. This might actually be a policy question. What's that? No, we can't have a discussion right now. How is it that the commissioner or the commissioner's agent could potentially the ways that they could identify public risks? Is it through like a tip hotline? Is it just through like your standard inspections? It's standard inspections.
Through standard inspections. Yeah.
Okay.
Yeah. I mean, we do have aquaculturists who will make observations on their own. Like we've had that example of the gaping oysters, and an aquaculturist will call us and say, my animals are acting weird and I don't know what's going on. Can you test them and find out what's happening here for me? So we do receive information in that direction as well, but this was more about when we're out there on the water inspecting leases and license sites and we see something concerning.
I have a question. Who are we worried about weaponizing that information? I mean, is it competitors or customers or advocates, or like, what's the scenario that we're trying to prevent?
I hope this isn't out of turn. I've never worked with your committee before. There is a well-funded anti-aquaculture organization, and there's probably more than one, but one that very specifically targets and aggressively goes after aquaculture operations. So I think that it's not about protecting information from that particular group, but it's about, I think the concern is that this is information that you really need a lot of context around, and not being able to provide that in a way that we keep the data necessarily. So, if we go and send something out to get tested and it gets tested for an animal disease that's not of concern, we're not going to write a report about it, and explain why this isn't a concern for the public health or for other marine organisms or anything. And so I think without that context, it definitely can be weaponized against the aquaculture industry.
Representative Henderson?
Thank you, Madam Chair. What's prohibiting you from providing context to that report?
Just workload, I would say. I mean, if we are running samples and getting results, if it's it just gets very busy a lot of times. And I think taking the time to write a report every time we do something like this would just be an extra burden. But to answer your question more succinctly, there's nothing, preventing us from doing that. We would just have to make sure that we did do it.
Thank you.
Janet, do you know in the context of like potato crop inspections, I mean, are those results confidential?
I don't know. I did remember that this committee looked at public records exceptions for cannabis growers and licensors when they do the testing. So ordinarily, personally identifiable information about growers and things like that is not public. But if the Office of Cannabis Policy finds testing results that are of concern to the public, they are allowed to release where they got them from, which is sometimes a caregiver. That's sort of individual information about them. And they are allowed to release those results in that context. But I was looking at a whole slew of different testing regimes, and I just don't know which ones are really analogous and which ones are not. I could imagine a way that a form could be created that says public health risk, no public health risk. Whether that really is feasible or not, I am not a scientist who does this, so that could be a pie in the sky, kind of a hope that it could happen that way. There are also, for example, I was just looking for anything I could find in statutes. There are nutrient management plans under the Department of Agriculture, so that if you are going to be applying nutrients to your land, and you have to include in those the results of soil tests, the results of manure tests, and all different sorts of things. And under statute, if the department asks for it, it is kept confidential. So there are other types of things that are kept confidential. Now that could be because that's far more competitive versus your competitors, the other farmers. I don't know, because again, I don't work in either of these fields. So I was just trying to find comparisons. There are places where this type of information is kept confidential, and there are probably going to be places we can find where it's not.
Mm-hmm. Right, it's the context. Representative Sinclair, did you have a question?
I'm wondering if the department keeps records of interactions with the public when a complaint is, for example, called in. There would presumably be call notes or any other record to establish an audit trail. And if so, couldn't those records, which I don't see being made confidential here, be weaponized in the same way it seems the department fears? And in those instances, wouldn't the negative results of testing on those samples be a curative to that weaponization rather than the weapon itself that seems to be the fear?
Yes, I agree with you. We do our inspection program. We do get complaints from the public. We do log those. We do respond to them, and we conduct an inspection activity, which there is always a report, and those are not held confidential. I mean, I suppose in that case, the farmer could voluntarily disclose the sample results, and we just wouldn't be doing that. But I think there's a lot that we have that can be weaponized, that we hold that's not protected in the aquaculture program.
Other questions? All right, are we ready to start walking through the criteria and continue to discuss it?
Feel free to stay. Okay, so if we look at the statutory criteria, we usually look at A and B together. And in fact, they're mentioned in the memo together, is whether the record protected by the proposed exception needs to be collected and maintained, and the value of maintaining that record. And again, here we're talking specifically about the sample testing results, nothing else, just the results, unless one of the exceptions is met. And so the memo reiterates that it's important to protect public health and prevent the spread of animal disease, to be able to take the samples and have the results of those samples maintained by the department.
Committee members, do you feel like A and B are met?
Yes.
Yep. Okay, thank you.
And the committee was not aware of any federal law requiring the information to be confidential.
So committee members will put not applicable.
And then we usually look at any of the D, E, F, or Gs that are applicable. And so as far as balancing an individual's privacy interest and whether that interest outweighs the public interest substantially, the committee wrote that it believes it's important to keep certain personal information confidential, and that they believe that the language strikes an appropriate balance, especially where if there is a sample testing result that would be necessary to protect the public health, to reveal that they will do so. Or in the other two instances, which sound like they involve sort of important information for law enforcement or for licensing purposes. But I actually think we might be more focusing on E, even though that's written about D. I would suggest we focus on E because it's balancing the effect of public disclosure, whether it puts a business at a competitive disadvantage. Although I can see why they wrote it under D, because it's sort of the privacy interest of the business as opposed to a competitive disadvantage. Although I could see there might be situations where either of those could happen. And that's where they wrote what we've talked about earlier, where even if a testing result is benign, its very existence, if it's not properly understood, could lead to lost business.
Representative Sato?
Thank you, Madam Chair. Janet, can you show me in the amendment where personal information is kept confidential?
I don't see that.
So as you're reading it, it's personal information is not confidential.
Right. And I think probably what it's more, I think what this memo was trying to say is the fact of testing that it occurred, that might not put you at a competitive disadvantage, but as opposed to your peers, but as far as like selling your product, if the public is worried about it. So I feel like even though D is supposed to be about individuals, I think if you think of person the way some people do, including entities, their personal interest as opposed to competing with others. So I think it was meant more in that spirit.
So really looking more at E.
Yeah, I think it's more of an E
Yeah.
thing, especially if you consider competitive disadvantage, not just as against other aquaculture leases, but maybe as against non-aquaculture foods, which may not have that same risk.
Representative Pugh?
Thank you, Madam Chair. Are we at the discussion point for these or?
Yes, we're just talking about E, so feel
Okay.
free.
Thank you. I think I'm just not convinced that E is met here. I can see the concern. I don't know that it feels like a FOA exemption is the correct vehicle to address a lack of context for the public. I don't know that and I can actually see a situation in which withholding information in that situation actually adds to a level of distrust, and could also the fact of that could be weaponized against aquaculture, whether that's, whether that would happen, obviously we can't say, but I could see a scenario in which that would happen. And I guess like I can understand that there's a PR problem here for the aquaculture industry if these results are taken and weaponized, but I guess I don't feel that this is the appropriate way of addressing what is a communications issue. And also obviously the aquaculture industry itself could endeavor to educate the public with additional information. And I guess I'm not fully comfortable with the counterbalance to that being that the department has jurisdiction to disclose when it makes its determination. Because I think that if you look at something like water quality, for instance, there are different regulations, and what sort of meets that standard can vary from state to state. And there are some organizations that look at water quality, for instance, and they say, even the state, they can look at what the state designates as having met this threshold, but we actually would be more conservative if you're really concerned about your health or whatever else. I guess there are other concerns that I don't feel that having sort of one failure point or one decision point for what is going to be publicly released feels sufficient to me. So that's my thinking around why I don't feel that that E is met here.
Representative Sato?
Thank you. And I think I'm kind of in the same boat, especially if because of the main argument is competitive disadvantage. I'm seeing a situation where the notice is a public record. The fact that they've tested is a public record, but the results not being a public record. I can see that being weaponized against the entire industry, and quite frankly, maybe bringing the state into it out of showing like a lack of transparency. And so I'm not fully convinced that the way they've decided, what's been decided to be confidential public actually prevents a competitive disadvantage for businesses.
Senator Carney?
Thank you, Madam Chair. I'm going to be a little bit of a contrarian. Because when I'm looking at criteria E, I look at, what is the public interest in disclosure of records? And so what is the public interest in the disclosure of records that don't reflect any public health concern? So that's one thing. And then I appreciate what you're saying, Representative Pugh, about educating the public, but I think about oysters and Maine's economy and the tourism that is attracted by oysters. And if we have this public information that can be used to misrepresent there's a public health threat when there isn't a public health threat, I just am concerned that that's beyond the public interest, and that the public interest the line would be drawn where there's a public health concern. And I thought that this legislation actually drew that line really effectively.
Representative Sinclair?
Not to play counter contrarian to Senator Carney, but I think that there is public interest in knowing that the department has followed up on all complaints that may have come in, particularly those where the commissioner or the commissioner's agent has determined there's a risk to a potential risk, at least, to public health. So it seems that by not allowing the disclosure of those instances where the commissioner found out, okay, at least based on our sample size, whatever size it is, and whatever percentage that might be, we don't think there's a public risk. I think the public still has an interest in knowing that those complaints were followed up on. And I think the only way to actually establish that is by sharing the results of those screenings, unless I'm misunderstanding.
Well, the notice of the inspection is not kept confidential, so that would demonstrate that the follow-up occurred. Representative Lee?
I mean, if I were building this legislation, it seems to me the part that does need to be preserved for the business's interest is the preliminary components, the notice, the existence of the complaint. The public part should be the result, health risk, no health risk. And so I would almost completely reverse the legislation. I don't know if that's contrarian to the contrarian to the contrarian, but like protect everything beforehand as confidential, but make the result public.
Senator Carney?
What I heard, and maybe this is a question for the department, was that what would be kept confidential under this proposal is a disease that doesn't pose any threat of harm to humans. And so I'm having a hard time finding the public interest in making that information public.
Representative Caruso?
I'm not a marine expert, but in response to Senator Carney's question about what would be the benefit, let's say a neighboring farm or neighboring owner of the land, the waters next to that one that was tested, I'm assuming they would want to know because it can spread, just kind of the same way other farms above ground can spread or cross-pollinate or all of that. And my other question is, are any other sources of food protected in the same way? Like chickens, cattle, eggs, or is anything else protected with this?
Yeah, if you have an answer, please feel free.
I think in the first question that you asked about other farmers having a concern if it was there are diseases that affect the oysters that don't affect people. So in a situation, perhaps we would test oysters and find that they have MSX, which is a oyster disease that doesn't harm people. We would still make a closure of that area and prohibit transport, and people would know. So say, I'm trying to think of a water body that makes sense, like the New Meadows River. We would, if we did a test at a particular farm and found MSX at that farm, we would make a closure in that water body because it definitely is going to move around, not just stay on that one particular farm. And there are many farms in that particular harvest area. This is all hypothetical, of course. So we would close that area and we would say, we're making this closure in the upper New Meadows. This is the line. And the reason we're doing that is because MSX has been detected. But we wouldn't say MSX was detected on this particular farm, at this time, and that would be protected, the results of where we found it under this scenario.
Representative O'Halloran?
That actually makes sense to me because where it doesn't affect humans, but if there was a notice put out that somebody saw that there was some sort of contamination, then that could have a big negative impact on our industry, even though it doesn't affect, human consumption. And am I correct in thinking that's probably why we're doing it the way we're doing it?
Yeah. And could I add something here?
Please.
I would just say that we are aggressively forward in this space, and we are forward for incomplete reports. We are forward for things in various stages. So we don't always get the opportunity to provide it in a complete format. So even if we decided, okay, to provide context for all of these things, we're going to start writing a one-page report for every sample result we get that talks about that this isn't part of, a public health issue, et cetera. We might get forward before we have the opportunity to do that. And we don't, currently we've been instructed to hand things over in whatever format they're in at the time that people ask if they're not protected. And a lot goes out.
Would it be helpful to explain just with a little bit more detail, sort of the dynamic in this space that's resulting in you getting all these FOA requests?
I certainly can try, and I don't know how detailed you'd like me to be. There was a very contentious lease in Casco Bay a number of years ago, and riparian landowners who look out over the space that was eventually leased were adamantly opposed to it. They started a campaign to try and fight that lease. We have decision criteria that are very specific, and we follow the Maine Administrative Procedures Act to issue leases. And so if people don't have valid concerns that hit the criteria, the decision criteria, then we'll give the lease or authorize the lease following the decision criteria. So in this case, the lease was issued. It went to the Supreme Court, I think. In the end, the lease withstood that kind of challenge. And this group sort of was formed out of that experience to sort of challenge aquaculture all over the place. And, currently they're quite focused on Cook aquaculture, which does salmon aquaculture, finfish aquaculture in Eastern Maine. And they've challenged many leases. There are also people have told us that they've approached them and said, if you basically, give us money, we won't fight your lease. It's pretty, just honestly, it's quite ugly. And we're caught in that all the time with FOA requests. And we're talking to the FOA ombudsman, on a regular basis, what do we do in this situation? And, yeah. Does that
Thank you.
help?
It does. Senator Carney?
So there's an oyster farm, small oyster farm near my my neighborhood. And we were really excited to have it there because for us, it shows this, the developing of this aquaculture business, which is really good for the marine environment. It's good for the community because we have local oysters. It's good in general for the kind of tourism and oyster culture in Maine. And I can appreciate, because some people are very adamantly opposed to anything changing around their house, even though they don't own the ocean. And I can see where that would be a source of tension. And I said before, I feel like this legislation really draws a clear line at the threat to public health. And I would be concerned if we were jeopardizing these fledgling businesses, a lot of which are younger people coming to Maine, trying to figure out a way to establish themselves in our state's economy. And it would just make me, I would be worried about putting too many obstacles in their way.
Representative Henderson.
Thank you, Madam Chair. So I think I'm kind of agreeing with everyone that's spoken, and can see both sides of it. For me, I think the hinge point comes down to the department being the arbiter or the one that determines what is necessary to protect public health. Maybe it's our place as a legislature to weigh in there, maybe it's not, but that seems to be a relatively gray area, that it's just up to their determination on whether they think it's an issue with public health. Someone earlier had made a comment about whether it was a disease that impacts humans or doesn't impact humans. I think I'm mostly there with you, Senator Carney, on what you're saying. Do you think that needs that paragraph 2, subsection A needs a little bit of a finer point? I'm on page 3 of the amendment. Rather than just the department determining what's necessary to protect public health, if there's a way for us to clarify that.
Senator Carney.
So I'm not an expert in this, except that I will tell you that I think of the department's role as protecting the public health, because they, as the representative said, they close the fisheries in order to protect the overall health of the oyster fisheries in any given area if there's those oysters diseases. But I also, and maybe you can talk about this a little bit more, but there's very careful attention given to when people can harvest from any given area and what the quality of the water is, how long it's been since there's been a big rainstorm that would wash like human waste into the water. So I think that in my experience, the whole role that the department has is to make sure that this source of food is healthy for human consumption. And they do it in a lot of different ways.
I can provide some
Please.
additional context.
Yep.
In the shellfish world, so oysters, clams, mussels, things like that, Maine is a participant of the National Shellfish Sanitation Program, which is administered by the Interstate Shellfish Sanitation Conference. So that's a set of national standards that we follow in order to be able to export our shellfish across state lines. If we didn't do that, we'd have to eat all of our oysters here. So those national standards define in great detail what public health, and when we use public health in this context, it's sort of wrapped in that. And it defines what public health risks are as they relate to bivalve shellfish. And we are audited annually or every other year by the US FDA for compliance with those programs. So I do think that the department has a great deal of experience and sort of regulation around that idea of what public health is in terms of bivalve shellfish. I think that we do have finfish aquaculture in Maine, and I would say that perhaps that's a little less defined on what would impact humans, but most of the issues that, I've had experience with in the finfish world they involve the animal's health and not human health. But if it did involve human health, I think this would allow us to address that without a problem.
Anyone else? One thing I'm thinking about, and I'm trying to figure out how to fit it into D, E, F, or G. But when I was on the town council in my community, I recall a lot of frustration from landowners that the town didn't have more of a role in determining whether leases were issued, because the role of the town was simply to have the harbor master look at basically egress, like, is it going to create a barrier or blockage? And the people, so the controversy wasn't coming from between farms. The controversy was coming from property owners who didn't want a lease put in. So I'm trying to figure out, is that where that fits in? Because what you said previously about the dynamic there is sort of resonating for me in other contexts. Senator Carney?
Yeah, and I think the remedy, so to speak, for property owners is the lease mechanism and not retaliating by using information. And so I would be, again, I'm comfortable with where the line is drawn.
And just to follow up, and so you're feeling like E is met? Is that the one that you would identify of D, E, F, and G?
Yes, well, yes, I would say E. I mean, it's kind of a combination of D and E.
Mm-hmm. Other comments, Representative Sato?
Thank you. I guess where I'm struggling is understanding how keeping the preliminary notices public, but then the results of those notices confidential, how that also wouldn't hurt these farms. To like know that there was testing that happened and then the public can't see the results. Wouldn't that lack of transparency couldn't that also be used against the industry?
Senator Carney?
So I think industry-wide, if for every oyster farmer in Maine, the testing schedule is known, the fact that the tests happen is known, the fact that when tests show a danger to human health, those results are known. I think that if that's consistent across the entire oyster or bivalve fishery, then I don't think you have that problem with specific results in specific locations being necessary. Because people would assume that that there's not an issue unless there was an issue and it was a concern for human health. And therefore it would be made public.
Representative Lee?
I thought what we heard though is that that's not how the testing regime works. My understanding was they would go to an aqua farm, and if they saw an issue with the oysters, that's when they would collect the sample. And so the very existence of the issue and the provision of notice indicates that there's something that the department feels is wrong.
That requirement in here is that they can do a test if they've identified a possible risk to public health, animal health, or health of other marine organisms. They can't test otherwise.
I wonder if the question about the notice piece is more under the tailoring and whether the confidentiality pieces are linked correctly with the problem that's trying to be solved.
I do want to say, in the past, you have, and it tends to be around these fisheries type things, written back that you're not entirely comfortable, but you couldn't come to a conclusion. There could be a minority and a majority, and I would write the memo on behalf of the majority. You could say you want everything confidential unless there's a actual found risk to public health, not a suspected risk, like folks were saying. Or you could say, like I'm hearing other parts of the room, just make everything public and that will solve everything. People have all the information they need. So I think you have a lot of options here, and I'm not sure you're going to all agree.
Right, committee members. How does it work if we do a divided report in terms of going through the criteria?
Well, we can, so the criteria are there to help make sure you
Mm.
consider all the
Okay.
factors.
Yep.
Sometimes, like here, we start talking about it. So you are talking about all of the different factors now. There's no need to go one by one by one if you feel like
Mhm.
you've talked about, if somebody looks at one of these factors and says, "Oh, actually, we really need to talk about this one, then we should do it. But otherwise, I think if you know how you feel about this proposal and whether it's appropriately tailored or not, then we could just go to that part. I don't want to stop people from talking about things, but it doesn't have to be.
We don't have to be tied to
line by
this.
line by line. by line.
Yep. All right, Senator Carney?
How about if we put potentially or maybe or something like that for D and E?
Maybe. That's what I'll write.
Let's put maybe for now.
Shoulder shrug.
And so then I think we're at G1.
Yes, so G1 is the opposite one. It's just sort of like argue against the exception is public access to the record. Would it help ensure members of the public are able to make informed health and safety decisions? And I think that's sort of we've heard opinions on both sides of that.
Senator Carney?
And I keep saying the same thing over and over again, but I do think that where the line is drawn in this legislation is at the threshold of when the information would be necessary to the public to make informed health and safety. So I would say that G1 has been met, but I don't know that others would agree.
May I ask a question that I think might help?
Go right
And
ahead.
I actually don't know the answer to. So it sounds like Senator Carney is focusing on a disease, whereas Representative Pugh talked about like water quality. And I don't know actually what is being tested for. Is it only diseases? Is it also water quality? Like, what are these tests of?
This is related to testing the actual organisms. So in a fin fish environment, it would be taking fish and doing necropsies and testing them. In a shellfish situation, it would be taking a bunch of oysters and then processing them for testing. We do have an extensive and elaborate water quality testing program, and all of that information is publicly available. It's actually on our website and people can access it whenever they want.
So in that case, I would say for me, G1 is met because it's related to specifically a public health. Representative Pugh.
Thank you, Madam Chair, and thank you, Jan. I think the reason I was bringing up the water quality was just to illustrate that people have different sort of thresholds when they are considering what is safe for them or their families or whatever else. And in the example of water quality, those results being public, I actually think that's very helpful because then if you're really concerned, you can go and look and see, do I agree with the assessment made by the water district? Or in this situation, you could take the results and say, do I agree with the conclusion reached by the department that there is no public health risk? And I guess that's like the thing that I'm sort of stuck up on is that when you're deciding public health, the public sort of has the public needs to be able to weigh in on that, whether that's an individual to say, I'm somebody who would say, I'm going to defer actually if they say it's good, no problem. I can go ahead and not worry about it. But I don't know that I can make that decision for someone else. And my feeling is that having the underlying tests allows then people to, if they want to, do their, diligence and look and then accept the result, the finding or not. And the other thing that's sort of giving me pause is that as, a lot of public health issues, science sort of evolves, right? We didn't know that PFAS was a thing. We didn't know microplastics were a thing. It is only decades later that we find out, oh, hey, this thing that we thought was totally fine actually has very negative effects. And I worry in that situation too, like if there's shifting findings on things, not that this would happen, but I guess just those are the things that I'm thinking about that are giving me pause, saying that I feel that it's narrow enough, just to explain where my position is.
Yeah, appreciate that. Representative Henderson.
Thank you, Madam Chair. Did I hear you reference earlier that the department is connected through a federal program that actually defines what public health is and that you have to follow those standards
Yes.
in determining what actually is protecting public health, and therefore that would go into your decision making on what would become public and what would stay confidential.
Yes.
Can you
all the-
flush that out a little bit?
Yes, yep. There are definitions of explicitly things that we must consider, but to Rep. Pugh's point, I think that it does evolve over time. And so there is sort of a nebulous statement as well that says, or other things, that impact public health. So there is the ability to capture things that you wouldn't have conceived of, 10 years ago. PFAS is an excellent example. We discussed this in committee, and at a point in the committee discussion, we were, not me, the committee was debating adding a list of things that you could test for. And we argued against that as the department because we said you can't predict necessarily all the things that you 10 years from now, 20 years from now would want to test for. So I think, again, the short answer is yes and no.
Yes, go ahead.
Are there other reports that your department provides that in nature, there's a presumption of confidentiality with a few exemptions? Like, are there other reports that you provide that are inherently confidential?
So we have an entire landings program that is confidential. So harvesters and dealers have to report all of their catch and landings. And that's protected as confidential unless it meets a confidentiality rule, which is like basically a rule of 3. If you have 3 harvesters who are fishing in the same area, then you can release it. If there are 3 dealers, buying in the same town, then you can release that information to the public. But it's controlled by that rule of 3, so you can't know any one company or one fisherman harvester what they're doing.
And do you mind, Madam Chair? Okay. Is there what is the criteria in which you would determine that something would be forced to become public? Because it seems the department is apprehensive to release this information. That's kind of why I'm struggling a little bit with the department being the determining factor on what should and shouldn't be public, is it seems that there's an apprehension to make things public, and maybe rightfully so because of what you're facing, quite frankly. But what is the criteria that the department would go through to say, okay, we think it's met the threshold where the public needs to know?
We have our deputy commissioner is actually our FOA, sort of the final word on FOA. And she's a lawyer by training and takes it very seriously, as it's written, what is available through FOA. And I would say that we follow it to a T. I think there are often times when we feel uncomfortable about releasing stuff, but it's public records, our personal feelings obviously don't play into it. And so the few times that I think there's been some debate, we do things like illness investigations. So somebody gets sick and it's related to oysters, and we have a whole report, and harvesters' names are in there and restaurants are in there. And there's a lot of sensitive information, I would say. That all gets released. The only thing we hold back in that scenario is there are health reports called COVIS, which if it's a Vibrio illness, you have to fill out, the doctor has to fill this out, and CDC gets involved. That has patient information and that gets withheld. We just strip that out of anything that we have because it's actually held by CDC, and we tell people, go get it from CDC, and they know how to redact it appropriately with HIPAA, I think it is. So I don't know if that helps or not. And I don't think, if I may, I don't think that there's a hesitancy on the department's part. I think we can recognize and appreciate the industry's concern. But I think we will follow whatever we're told to do, obviously.
Any other comments? Senator Carney?
Yeah, this may be where we come up with 2 separate reports, but I would find that G1 is met. I mean, let's see.
Mhm.
I would find that under the language proposed by the committee she wants met.
I have a question just about that provision. I'm noticing, and this is on page 3 of the amendment. It says the department may disclose the results of testing. And then A is when the department determines that there's a risk to public health. Should that one be a must?
Did it get changed?
That would more
No.
clearly draw that line that I think
That's a good
you're trying to
suggestion.
get to.
It might have to be a shall.
It might have to be a shall. Thank you.
We'll leave that to the revisers.
Representative Sinclair.
I wonder if for the policy committee, it might be more helpful for us as a committee to reflect the committee's sentiment as a vote rather than just writing maybe. We definitely have at least one maybe, and I suspect we may well have several more. It doesn't particularly give good guidance, I would think, to the department if all we say is, maybe.
It wasn't our intention to send back a letter that said maybe. I think that was a suggestion to help us keep moving through the form and then circle
We'll
back.
have
but I
detail
appreciate
on the
that.
back.
Yeah, we'll have all the details in the motion and the letter, but thank you.
I write based on the back.
Okay, and so then we get to H is the proposed exception as narrowly tailored as possible.
I think people are gonna disagree on that.
I agree. I would actually want the committee to look at whether the notice should be confidential. So it's sort of like the opposite of narrowly tailored.
And the other criteria, I think I'm gonna write down concerns about the notice. Because that's sort of the separate issue folks have been discussing.
Mhm. Do others want to share views on whether it says narrowly tailored? Oh, sorry. Did anyone else want to share any comment on H? Representative Sinclair?
For me, in order to weigh in on whether it is as narrowly tailored as possible, we have to interpret the phrase narrowly tailored in terms of the stated objectives and in terms of the information availability matrix that we've been presented with. Given that we know that information will continue to be available to the public, A, that a complaint was made, B, that notice was issued to a particular entity. The only thing this would make unavailable is that information which would show that the risk was not substantiated. So to my mind, that doesn't meet the narrowly tailored aim of trying to protect the competitive bargaining position or marketing position of any particular farm.
I might suggest maybe taking a straw vote to see which way folks are going, and then we can focus on what the majority report is and what the details of that motion would be. Does that make sense?
It
to
does.
folks?
So let's start first with those who support the confidentiality of this information in a general concept, subject to perhaps some small changes, such as changing may to must or shall.
Do we think it's complies?
Do we think it complies? All right. And then let's see a show of hands for those who are feeling that the requirements are not met.
Yeah, and I think those people might be split of who wants more disclosure and who wants less disclosure completely.
Okay, so a three-way report back to the committee. Oh, yes, sorry. And I'm not sure if I got Representative Caruso either. Okay, so do you want to go first, Representative Henderson?
Like I said to Representative Sinclair, maybe. I honestly, I think I hate to say it, I'm not quite at any specific place yet. I keep coming back to section 8 on paragraph 2, subparagraph A, where it talks about the department determines the sample is necessary to protect public health. But then we've been talking about language concerning danger to human health, right? That the department is going to take into consideration if it's a danger to human health, but that's not what's written in here. And I still don't really fully know what criteria the department's going to use to determine what is like what is necessary to protect public health. That for me is the crux. So I don't know if it needs to be better protected or not better protected. I'm just still kind of fleshing it out in my mind. So stay tuned.
Senator Carney?
Yeah, I agree with you in that we don't really know because we're not the policy committee for this area. But what we have heard is that there is this very extensive set of state and federal regulations that apply. And so this is operating this is a little subset within that about what information can or can't be forwarded, basically.
Jenna?
So I'm trying to think of options here, and I think in this type of situation in the past, we've seen like reports that at least give you non-identifiable information. So like we had this many complaints, we did this many tests, we found this many of, I forget the letters you gave for the oyster disease that people can't get. We found this many for, ZQR. We found, like these 4 different diseases, but then we found like 5 that were this one that involved paralysis, I think she said. That didn't sound good. So, having that type of information, this many waterways were closed, I don't know if that is helpful or not, or if we want, or some of you want the more nitty gritty because you're the consumer buying the oyster. Luckily, I don't eat that.
I have a question. I think one of my kids actually got Vibrio once, and it was the CDC tracking us down, and it was a very, very big deal. And so I'm recognizing also that you're almost recognize a potential for a human health problem, but the CDC is separately tracking actual human health problems.
Correct. CDC generally gets the complaint from an ill patient. And then epidemiologists who are trained in tracking human health issues, they'll interview the patient or the patient's relatives and get a food history. And if the food history includes oysters in a reasonable time frame where they got sick, then they'll notify the Department of Marine Resources and we start conducting a trace back. And so that trace back involves, the patient ate at this restaurant. We go to that restaurant, we collect their shellfish tags, and we find out where they were harvested, if it went through other dealers before that, and we get back to the harvest location. So somebody might get sick in a Portland restaurant eating oysters, but they actually came from Virginia. And we can find out things like that, not to throw Virginia under the bus. But we can find things out like that through the traceability path. And I think that that's also why the public health issues can't be confidential, because all of that goes to FDA, to, a variety of places. That trace back has to be shared.
Yep. Okay, thank you. Other questions? Representative Lee?
Just was gonna note that I have a problem with the Portland restaurant serving Virginia oysters.
That's not subject to a FOA exemption. Okay, so Janet, do you want to propose a couple of options? Is that where you were going?
I actually have a couple of thoughts. One of them might be, although I feel bad for the folks who are here, if you're ruminating on it, we might set it aside, do the 2 from HCIFS. It might get people's thoughts sort of in the background. If folks don't mind, I feel bad that people are waiting. But sometimes that helps, is just give it a little time.
Yeah. How do folks feel about that? We have spent a good amount of time on this already. I just want to make sure, would it be helpful just to leave some time to let things buffer? Okay. All right. Well, with apologies to the folks who have been waiting,
No.
we will continue our work and we will set it aside and come back to it. Oh, yes. Yes, we're not authorized. Yeah, we're not authorized to meet any more days at this time.
Thanks.
No, I don't care which one.
Okay, so let's do LD 2202. This is from HCIFS. This is the one that they requested earlier. 2202. It's numeric,
It's in,
so toward the back.
That's a really good organization.
Salt soupy. Is it okay to start?
I want to make a public service announcement before we start, which is that Representative Kuhn and I have a couple of meetings that we need to do this afternoon. And so we'll be here and we'll be able to come back when you vote on things. But in a couple of minutes, we're going to have to start doing our other meetings. And so just to the extent that we can efficiently work through, that would be really great. Okay, Jen, all yours.
Certainly. LD 2202 is an act to require notice to the Attorney General prior to the merger of certain healthcare entities as recommended by the Commission to evaluate the scope of regulatory review and oversight over healthcare transactions that impact the delivery of healthcare services in the state. Okay, nobody left. All right. So this is a unanimous straight ought to pass report from the HCIFS committee, and we have the analyst from the committee here who knows all about this bill. But what my understanding is, if we look at the bill, LD 2202, there is a federal law, the Hart-Scott-Rodino Act, which requires certain information to be filed with the federal government prior to a merger of certain entities. What this bill does, LD 2202, is say that if it's a merger of healthcare entities, and you'll see the definition of healthcare entity right on the first page of the bill, then that notice that you have to give to the federal government, which is all defined in federal law and federal rules, will have to also be given to the Office of the Attorney General prior to the merger. And then on page 6 of the packet or page 2 of the bill, it provides that the information provided to the Attorney General under that section is confidential, except the Attorney General may, subject to a protection order from an agency or court or judicial officer, disclose the form and any additional documentary material or other information in an administrative proceeding or judicial action. In addition, the Attorney General of the state can share the information with the FTC or the DOJ at the federal level, antitrust division. And the FTC is who makes the rules about what's in that form. And then also the Attorney General of Maine can share this pre-merger information with the AG of another state that has a substantially equivalent statute. But they'd have to give notice to the healthcare entity in advance of that disclosure to another state. So if you look, it's pretty straightforward what the HCIFS committee has told you about this form. And maybe I'll just read through it real fast and then you can make your straw votes. So as far as the need to collect the information and the value in maintaining the information, I did skip a very important sentence I underlined at the top of the page 2 of the memo. is that information provided by the Attorney General's office to the HCIFS committee noted that prior notice of these mergers would allow our state AG an opportunity to determine whether a proposed merger involving a healthcare entity has antitrust implications, because we do have antitrust state laws that they have the authority to enforce. So if we look at the need to collect and the value of maintaining the information, the bill requires the healthcare entities to provide electronic notice to the AG of potential mergers by filing the same notice and materials at the time they file those information with the Federal Trade Commission under federal law. And this allows the Attorney General the opportunity to determine whether a proposed merger involving a healthcare entity has antitrust implications under state law. And then as far as federal law governing this material, when the information is shared with the FTC under federal law, if you look, that was included in your packet, the Hart-Scott-Rodino Act, which you can see excerpt from in Title 15, Section 18A of the United States Code. This is all about the pre-merger notification that has to be submitted. So it's page 8 of the packet, or the second page of the handout. That's just particularly that law. You could see subsection D, commission rules, where it says that the FTC decides what has to be included in this notification. So all of that's done through rulemaking. I actually downloaded from the rulemaking websites an actual copy of one of these forms if you want to see the information that has to be included currently. The rules are very long, so I didn't download the rules. Colleen also considered downloading the rules, and we just decided that was a lot of information to download. But we do have the form if you want to see it. And then on page 9 of the packet, page 3 of this federal law, the federal law says that any of this information that's filed with the FTC or the federal attorney general is exempt from disclosure under FOIA, and that no such information may be made public except as relevant to any administrative or judicial actions or proceedings. Or it could be disclosed to Congress. So that is the relevant federal law. This is pre-merger notifications of healthcare entities. So paragraph D about individual privacy rights was not implicated according to the committee, but paragraph E certainly was according to the committee, because public disclosure of the information required in this form could jeopardize the transaction. Because remember, this is prior to the merger, and affect the healthcare entity's competitive position toward other healthcare entities. And the committee believed that those interests outweigh the public interest in full disclosure of the records. And that does seem to mirror the way that Congress has weighed these competing interests as well. And there is a provision that allows disclosure for investigative and law enforcement purposes, and that hopefully helps take care of the public interest piece. There wasn't a thought that F, G, or G1 were applicable to this exception. And as far as narrow tailoring, the committee thought that it was appropriately drafted and as narrowly tailored as possible, because it is intended to mirror the requirements of federal law. And it's just sort of a law that's piggybacking on this federal law disclosure requirement and then posing the same types of confidentiality protections as the federal law does.
Thank you, Janet. Committee members, in light of the intent of this legislation to simply mirror federal law, including the confidentiality aspects of that federal law, but still to allow it to be provided to the Attorney General in order to protect against monopolistic behavior, do we feel comfortable moving to the last page of the analysis rather than going through the criteria? Okay. Would anybody like to make a motion? And then we can discuss the motion. Representative Kuhn.
Thank you. I move that the proposed public records exception meets the criteria listed in Title I, Section 434, and the Judiciary Committee approves the proposed language without change.
Seconded by Representative Sato. Discussion, committee members? Representative?
Thank you, Madam Chair. Was there, I support the amendment, or the motion, but was there any discussion on the amount of time, like what federal law requires for retention years?
In terms of the 75 years?
Correct.
The committee didn't have any specific discussion about that. I think they would be comfortable with the
standard 75. I don't think there would be any reason to deviate from that under state law.
I mean, is there nothing in the federal requirements that would require it to be longer?
I don't recall that there's anything specific about that. There might be something about a certain period of time retention.
Just, this archives piece sort of overlaps with retention,
Yeah.
but there will be a retention schedule that applies that may have it retained shorter than 75 years and destroyed earlier. It's just if it happens that the retention schedule is longer and it is retained, then it no longer remains confidential at that point unless you make an exception.
Okay, thank you.
So I don't know what the retention schedule is for this particular piece of information, and it might not be made yet because it's not being collected yet.
Yeah, the discussions that the committee had with the Attorney General's office really wasn't with the committee because this came out of a commission recommendation, a legislative study commission. So most of the discussions that the commission members had were with the representatives of the Attorney General before it turned into a committee recommendation and a bill. But at that time, they don't often get, formal notice of these mergers prior to them happening. What's noted in the memo is this is based on a uniform law that's been drafted that would apply to all industries because the Hart-Scott-Rodino requirements under the antitrust provisions apply to mergers of all types of businesses. But the commission just really was focusing on healthcare transactions, so focused their recommendation on this. But it was a way for the Attorney General to gather materials. They do some pre-merger investigations now, if they have the capacity and the resources, and they know about them ahead of time, whether it's through information that they gather through newspaper or public information. Sometimes entities will approach the Attorney General's office prior to a transaction happening on a voluntary basis. This would just provide them for those really large transactions that trigger the federal requirement, an opportunity to get a formal notice and get all the access to all the materials that are provided as part of that notice at that time, which would benefit their inquiry into whether or not it implicates the state's antitrust provisions.
Any further discussion, committee members? So we have a motion that's been seconded that the public records exception meets the criteria without change. And also, I think we've fleshed out that there is no need to adjust the retention schedule at this point. Is the committee, is there any more discussion? The committee ready for a vote? So by hands? And that is unanimous of the 8 of us who are present. And Representative Lee, you have the distinguished honor of chairing the next POA review.
So would okay, the next one is LD 2201. It should be very close to LD 2202.
You'll notice, folks, that your binders are arranged in alphabetical order.
So LD 2201 has another short and quick name, an act to implement certain recommendations related to the regulatory review and approval of certain healthcare transactions involving private equity companies, hedge funds, or management servicement organizations. Again, from the commission to evaluate the scope of regulatory review and oversight over healthcare transactions that impact the delivery of healthcare services in the state. So this is a bill that wasn't voted straight on to pass. So this is a unanimous committee amendment, and Colleen McCarthy-Reed, our fabulous HCIFS analyst, has provided a copy of the amendment for you so you can see all the original bill plus anything that's shown to be changed, either stricken or in bold and italics if it's added. And the particular provisions that you are reviewing, I will point out to you in a second, but I did want to explain as Colleen explained, probably she should be saying this, but this bill proposes to establish a regulatory process for notice, review, and approval of material change transactions. And material change transaction is a defined term in the bill. And they are defined as transactions when a private equity company, a hedge fund, or management services organization acquires a majority ownership interest in a healthcare entity or takes operational control over a healthcare entity. If this material change transaction is proposed, then the Department of Health and Human Services is directed to complete a review of this material change transaction in consultation with the Office of Affordable Healthcare. And those entities, the department and the Office of Affordable Healthcare, can request information and documents from the parties to conduct the review, including cost impact and market impact questions and documents. And then it provides for confidentiality over those types of gathered materials, as well as there's provision in the bill that talks about information that the main health data organization has about the ownership of different entities. And a piece of information that they have includes different business identification numbers, or it could be a social security number if it's an individual who has an ownership interest. And so those are the type of these material change transactions, and then these ownership information points that the main health data organization has. So as if you look on page 2 of the memo, under the bold information regarding proposed public records exceptions, there are 3 types of information that the bill as amended would keep confidential. The first is proprietary information that's provided either to the Department of Health and Human Services or the Office of Healthcare Affordability as part of their review of the material change transactions. And there is a specific process that I can show you in the language of the amendment where the person submitting the information notes that they believe it is proprietary information and should be kept confidential. And then either the department or the office has the ultimate say. This was an issue that came up earlier, so this has been addressed in this language. It's not sort of an open-ended inquiry as we had with a different bill. Any work product of the Office of Affordable Health Care related to its review is confidential, but not its final decision. And then individual tax identification numbers that are either social security numbers or a similar number for a business, as long as that business's number is not publicly available. Those are the things that are being kept confidential here. If you want to see that in the amendment, if we look at the amendment which was attached, if you want to know the types of transactions we're talking about, the definition of material change transaction is on page 2 of the amendment. It's subsection 7 of the definition section, just so you know what transactions we're talking about here. This is like private monies have control over healthcare entities. The confidentiality provisions begin on page 3 of the amendment. So section 372 is the Department of Health and Human Services section about reviewing of proposed material change transactions. And you'll see there's a notice that has to be provided to the department. And in subsection 1, paragraph B, it tells you the types of information in that notice. And then paragraph C says that the information is public unless the submitter says that it should be designated as confidential and the department determines it contains proprietary information. The definition of proprietary information at the very bottom of that paragraph matches identically with the definition of proprietary information you have seen several other times this session. So it's the same definition. In the middle of the paragraph C, you'll see that the department can exchange confidential information with the Office of Affordable Healthcare because they have to do their own review. And then they can also disclose information under paragraph D. This is all related to whether it's narrowly tailored. So if you see under paragraph D, the Department of Health and Human Services shall post on its publicly accessible website certain information about these material change transactions. And you can see subparagraphs 1 through 5, all of the information that's going to be publicly available right on the website without you even needing to make a FOA request for it. It's just that the proprietary information is proposed to be kept confidential. If you look on page 5, you'll see a subsection 3 talking about a comprehensive review process, which includes a lot of information under B, paragraphs 1, it goes all the way through 15 on the next page. This includes prices that are being charged, market share, staffing levels, any lease or real estate agreements for the healthcare entity, debt to equity ratios, lots of things like that. Some different market share things on the back of the page in 12 and 13. And if you move down to paragraph D, it provides, so this information is going to be given to the Office of Affordable Healthcare and analyzed as part of analyzing this material change transaction. And if it's proprietary information that the office has as part of this review, it's kept confidential unless the entity allows you to release the information. Or if the office needs to have an expert or a consultant that's under contract to review the material, they can disclose it to them. As far as narrow tailoring, it's important to know on page 7 in paragraph F that the Office of Affordable Healthcare has to produce a report on its review of the material change transaction and market impact report, and that report has to be posted publicly, but it may not disclose confidential information. So this is really a confidentiality protection that's just about the proprietary information, any ultimate outcomes, and certain information about the transaction as a whole is going to be automatically publicly available if this language were to be adopted. The last slightly different confidentiality exception in this amendment is about information that the health, I'm going to say their name wrong. Can you say their name?
MHDO.
MHDO.
May help that organization.
Thank you. Information that they have, if you look on page 10 of the amendment, there's a subsection 2 for this law that says reporting of ownership and control of healthcare entities. So every healthcare entity has to tell MHDO originally and then after any material change transaction about who is the owner, who are the owners of that. And included in that information that has to be shared under paragraph D here, we have business identification numbers, which could be taxpayer IDs, national provider IDs, employer IDs, and CMS certification numbers. And then if you look, subsection 4, which starts on page 11, it says, how is all of this information that MHDO has about the ownership of these healthcare entities protected? It says information provided under this subsection is public information except that a taxpayer ID that happens to be a social security number or a business ID that's not otherwise publicly available will be kept confidential. And that's for probably obvious reasons. So those are your two things. There's all of the reviewing of the material change transaction where there might be proprietary information and just the proprietary information is kept confidential. And then this main health data organization is only going to be protecting social security numbers. I mean, I'm sure other things are protected, but newly protecting social security numbers and business ID numbers that aren't public already. So that's what you're looking at here. Did I capture that right? Okay.
Any questions, committee members? I have one. I'm trying to understand the work product. Is that like litigation work product?
No,
Or
that
is
would
it-
be the sort of the draft reports, the materials that the Office of Affordable Healthcare is using for their cost and market analysis. They have a really focused role in the for material change transactions that are going to be subject to a comprehensive review. And as Janet mentioned, they're going to be looking at sort of the cost and market impact. And there's like 15 subparagraphs of things that they're going to be asked to look at in terms of how the potential transaction might impact, statewide, healthcare statewide. So they're looking at a lot of different factors. So the idea was that their findings and their report would be public, but all of the analysis and the development and the sort of drafts that they would be putting together could be kept confidential, and the final public report would be the final report, and their findings would be the public information.
And is the idea there that having the preliminary information available might disrupt those markets? Or-
Similarly, I think to the belief, and the rationale for why proprietary information would be kept confidential. Some of the specifics of that would be subject to that same sort of policy rationale. And that it made sense to the committee to make their findings and their recommendations and the determination, the report public. But there wasn't there wasn't the same necessity to make all of that sort of like underlying information public because it may fall into the same category of sort of proprietary, the same categories of information.
Anyone else have any questions? I have another one. What is the process? We've had a few of these proprietary information ones, and how is the proprietary information designated as proprietary?
So you've probably heard there's like in current law, there's like a range of how entities and agencies respond to proprietary information, and probably like DEP in Title 38, that's the most expansive and detailed. And then others are sort of modeled along the lines of here, whereas, there has to be some identification or demonstration by the party submitting the information that the information they believe it's proprietary. So that would be the same thing here. The submitter would be required, as Janet mentioned, there's a lot of things that would be required to be filed prior to a transaction in terms of the notice, but then there's additional documents and information that would be provided to the department. And then as part of that submission, it would be on the part of the healthcare entity submitting the information to say, we think this needs to be confidential. We don't specify sort of how it will be done, but I think most agencies typically will like stamp it or segregate it, have some way to identify that someone is claiming this would be proprietary. And often I think as I understand it, in the DEP process and some other processes, they just stamp it and they don't necessarily make a determination that it's proprietary until someone is making a request for under FOA. And then at that point is when they take a look and make it and go through the sort of analysis, like, do they agree that this needs to be released or not? Similar to how agencies are required to undergo any request for public documents under FOA. There are a lot of confidentiality exceptions, and they need to go through a whole record and determine, what within this request is confidential because we need to redact a social security number, for instance, similarly. So I think there is rulemaking authority granted to the department here. But I think the committee was comfortable sort of having the designation be done by the submitter. And then it would be a determination by the department or the Office of Affordable Healthcare in this situation as to whether or not it met that definition of proprietary information. And then they would be able to, if they did so, then it would be designated confidential and not released.
Thank you very much. Janet, would you like to lead us through the purple page?
Certainly. So for paragraphs A and B, the need to collect the information and the value of maintaining the information, the committee indicated that the records provided by healthcare entities need to be collected in order to enable the regulatory review process for these material change transactions. And it's also important for the information to be shared between the department, which is part of the review, and Office of Affordable Healthcare and any consultants they have to complete the review that's envisioned by the bill. In addition, with regard for the information to the main health data organization, it's important for this information to be collected to ensure transparency related to the ownership and control of healthcare entities and determine the extent to which private equity companies, hedge funds, and management service organizations own or control healthcare entities in the state, the latter being sort of the whole focus of the material change transaction. And I think a lot of the recommendations from that commission over the summer.
What do we think, committee? Have A and B been met?
Yes.
All right. Looks like C is not applicable.
That's my understanding.
Agreed.
And then for individual privacy rights, most of the bill involves proprietary information, which wouldn't involve individual privacy rights, but there is a provision for any individual tax ID number, for example, a social security number reported to the main health data organization to be protected, and that is individual privacy interests.
In that narrow section, do we think that D has been met? Okay.
Okay, so then paragraph E is really the rest of the information. The committee, HCIFS committee believes that public disclosure of this proprietary information prior to material change transaction couldn't affect the healthcare entity's competitive position toward other healthcare entities, and that those interests outweigh the public interest in full disclosure of the records. They also note that it's only proprietary information that's confidential, none of the other information that's in these records. And I think, as Colleen pointed out, if this determination is made when the request is made, that actually will cause only more information to be released, not less, because anything that's publicly available somewhere is no longer proprietary. So if you look at the point of when the request is made, that actually is the most publicly accessible way of doing it.
Do we agree that E has been met? Okay.
F and G1 don't appear to the HCFS committee to be relevant.
Do we agree that none of those are applicable? All right.
So then the question is whether this is as narrowly tailored as possible. And so they did point out that it is common throughout the statutes to protect proprietary information, but only proprietary information is corrected. And this is where I did want to point out what is in paragraph D is that there is a lot of information that's automatically going to be posted on a publicly accessible website about these proposed transactions. And then the final report of the Office of Affordable Healthcare will also itself be public, to the extent that that helps you evaluate the narrow tailored question.
Do we agree that this is narrowly tailored? Okay.
Any other criteria? They point out here what I mentioned before, that the final reports are public. I don't know if others have any ideas of other criteria.
Yeah, I think it's notable that the bill is sort of to create something so that you have more public information
Right.
that
that's
isn't
true.
presently public. So
I don't know that 2A or 2B, 2B definitely isn't applicable because it wasn't public records before. And I don't know if you care if it might become public after 75 years.
do we feel 75 years is enough? So at this point, I believe, Janet, we can take a motion.
I believe so.
Representative.
I move that the proposed public records exception meets the criteria listed in Title I, Section 434, and the Judiciary Committee approves the proposed language without change.
Do we have a second? We have a second from Representative Pugh and a third from Representative O'Halloran. And we need to get a senator before we vote. Okay, so we have a motion, a second, and a third. Do we all agree on the motion? Raise your hand. if You do.
Do you want to abstain? I probably, I don't even know the LD number.
So this is LD 2201. And this is a bill from the HCIFS committee, which provides that if there's going to be a transaction of healthcare or some kind of transaction that involves a private entity owning a healthcare entity, proprietary, I'm gonna be very simple, proprietary information that the state gets to review that would be kept confidential. And then if the main health data organization is told somebody's social security number or the business equivalent that isn't already public, then they would keep that confidential. So, and the committee motion was that that's fine the way it's drafted. Because I knew she cared.
All in favor of the motion? Any opposed? Representative Sinclair, would you like
I'm in
to?
favor and not opposed.
Yes.
Thank
Thank you. Unanimous of those present. And yes, Representative Pugh.
Thank you, Mr. Chair. I'd like to reconsider all the bills we did this session. Can we just do that quick?
Is that a strike and replace with alligator pits? All right.
Do we want to take like a 2-minute break
Yes.
before we do Marine?
I think
Go back to
I think
Marine?
it's important for us to ascertain whether Senator Carney and Representative Kuhn are available, because I know they had thoughts on the previous issue. So we'll be at ease for the time being. Folks, it's gonna be about a half an hour, so if you have something to do, do it.
Yeah, thank you. Welcome back, committee members. We are resuming our FOA review on LD 2025. Thank you for everyone's patience here in the room. Representative Lee, would you like to be recognized?
Sure. I think we're probably going to come out of this with different reports, but mine would be that the proposed public records exception does not meet the criteria listed in Title I, Section 434. And the reason that I would find that is because as presently written, I don't think it effectively solves the business being at a competitive disadvantage because it's protecting the wrong information through its confidentiality provisions. So my suggestion for changes would be essentially to make all of the preliminary information confidential, but the final decision, and the final decision being whether or not there is a public health risk to humans, is the decision that would be public, whether that's a yes or that's a no.
So only public if there's a finding of a human health.
No, I think the finding that there isn't a human health risk would also be public as a final decision. Yes.
Representative Henderson?
Thank you, Madam Chair. Can you define what you mean by preliminary information?
Yeah, so the complaint and the notice. And any preliminary investigatory materials like work product of the department in that investigation
So just final result.
would be public.
Yes, Representative Henderson?
So Representative Lee, would that also include preliminary decisions, i.e. complaints and investigations that had no findings?
My understanding is there's going to be a finding one way or the other, whether there is a public human health risk. So yes or no.
So if I may, Madam Chair.
Yes.
So the complaint, the report, so the complaint, the notice, the preliminary investigation, and the report would all be confidential if there was no finding. But the complaint, the notice, and the preliminary investigation and the report or preliminary investigation would be confidential. But if there was finding, it would be public.
Not quite. Let's see, try it one more time.
So there's the whole process and if there's a finding and then there's a whole process, if there's no finding, walk me through each one and what pieces would be confidential and not.
So from my view of it, you would still, under either scenario, the only thing that would be public would be the final decision. And whether that final decision is exonerative, if it says there's no human health risk, that would be public. And if it says there is a human health risk, that would be public as well. But none of the underlying materials would be public. The rest of that would be confidential.
Yes.
So if I filed a complaint, there's no way for me to see with the process of the complaint, the final disposition of that complaint, or even my complaint at all. Because it's all going to be confidential. If there's no finding, it's all going to be confidential.
You've made the complaint. You're aware of what the complaint was. You know the final determination of the complaint when it comes out of the department. Because there's a final decision.
I think we're talking about final decision, but I think what you're saying is the testing results, no matter what the results are, the testing results are public. It's everything prior to the testing results that's not public. So if the testing results say no diseases at all, public. The testing results say animal only disease, public. The testing results say human disease, public. All of the testing results are public.
I thought we were just talking about human health, not animal health.
Yeah. So the determinative thing is, I understand it, and if I'm mistaking what the actual underlying purpose of the bill is, please correct me, someone. But the purpose of the sampling is not to determine if the animal has a health issue. It's to determine
is also
whether
the
the
purpose.
animal health issue leads to a public human health risk. Am I misunderstanding that? Okay.
Yes, the testing is if there's a possible risk to public health, animal health, or human health, or other marine organisms. So they might find a marine organism health issue, and then, as they said, close off the New Meadows River. And say these groups were not going to be transporting organisms around it. But what the scheme was is that as far as public disclosure, if it was a public health risk, then they would disclose it. But that wasn't the only thing that was being tested for.
Senator, do you have a follow-up?
I get that it's not the only thing being tested for. It's sort of like, why does that result? I'm asking myself a question, so I'm gonna.
Let's give
I'm gonna
Senator
pause.
Carney a chance. Go ahead.
Yeah, the more I think about this, the more I think that the language that has been brought to us by the bill sponsor and the committee and the department has been worked on thoroughly by people who really intimately understand this industry. And I love to eat oysters. I like to look at the oyster nets in the ocean, but I don't know all the intimate details. And my inclination would be to say that the exception meets the criteria without change, because I think we could spend 3 days and still not know as much as the people who put this together. And we're always going to miss something that operationally has a negative impact. So that's my 2 cents.
And I think we have this written as the proposed record exception meets the criteria without change or with a change. I think it is possible for you to say that you don't understand it well enough. I would write that nicely. To make a decision so you're willing to defer to the committee without saying that you know exactly that this is exactly the right balance, but that without really complete understanding of all the intricacies of aquaculture, you're fine deferring. I'm not saying you need to do that, but I don't think that we need to be held to just exactly the way this rubric is. You've done your analysis. That's what you're required to do. And you're thinking hard about it. That's what you're required to do.
Senator Carney.
I think we need to talk about this for at least 4 more hours before we get to that point.
Okay.
Actually, just until 12:01 this morning. That would take us into April 1st.
And then we'll just say April Fools.
It's like for a pose.
But seriously, I
Yeah.
do like the suggestion of saying that we don't feel like we
Yeah.
have a grasp on how to make it any different.
Yeah, and honestly, the fact that we're in the last 2 weeks of session also might make that the most practical result at this point, and maybe in the future, someone will want to re-examine that question. Representative Lee?
Yeah, I mean, I was in the middle of my report, and I still think my suggestion would be that there's a need for a provision of confidentiality to the other or the other complaint and notice materials that are contemplated in the bill. And so that would be my report, is I'm making a suggestion based on their knowledge to consider the additional confidentiality to those provisions.
Okay. Representative Henderson?
Thank you, Madam Chair. I think I'm more comfortable with that last suggestion, like, hey, we don't have a general consensus amongst committee members or how to move forward, but we want the committee to move forward in some way. And then if there's a potential floor amendment that needs to come in place, rather than trying to send it back to the committee to be reworked with like 9 legislative session days left. So.
Representative Lee?
And my understanding is Janet's just gonna send a letter anyway to the committee whose chair is here presently and listening to us. And so it's in their court once we send that.
And keep in mind, our FOA reviews are advisory. They're not binding on the committee. We're just applying our expertise in this area.
So what I don't understand is if what the proposal is now is just to say generally, there's no general consensus how to move forward. Don't entirely understand all the intricacies, defer, Or are we saying, but we want you to consider? I just don't know if we're adding in what Representative Lee said.
Senator Carney?
So a question for my friend, Representative Lee. Would you say instead future consideration should be given to? So that at least there's some protection in place now, and then that how to be more comprehensive could be looked at by the Committee of Jurisdiction next year.
I'm amenable to that. Yeah.
Can you say that again? I'm sorry. I was writing something else.
Okay, so the recommendation would be that future consideration be given to including other records in the group of confidential documents, or making other records that precede the test results confidential to the extent that that would continue to protect the businesses involved.
Thank you.
All right, committee members, is that a formal motion to submit that response? Submit that? Yes. All right. Do we have a second? And then we'll do a show of hands.
Second.
All right, thank you. We'll try to do this just by a show of hands. Is everyone in agreement with that approach? Oh, no. Okay. Okay, thank you. We have two folks who are not. Did you get all those hands, Janet? Okay, put your hand back up if you're in support of sending the letter.
Thank you.
Okay, and then Representative Sinclair, Representative Pugh, do you want to state what your report is?
Sure. Thank you, Madam Chair. I would just like to submit an alternate recommendation, which is that I think I continue to have concerns that the test results specifically should also be public for help for the public to determine, what constitutes public health risk. So my suggestion would be that it does not meet this requirement because it is not currently narrowly tailored enough, because I believe that the test results, it's important that those be public.
So no confidentiality provision.
Yeah.
Is that the same?
One of the things that I like about that suggestion is that it would also enable members of the public to see if there is one particular group, for example, that is bringing forward a number of complaints that end up being not substantiated, that would help the public to understand that the problem may not be with the farms. So I generally believe that the more information we provide, the better. And I think in this particular circumstance, that's particularly true.
All right, thank you. So the letter will reflect that two members felt the exception had not been met.
Yes.
Okay. Anything else on this item? No. Yeah, we do have one language review left.
Good. At this point, evening Judiciary Committee members, I am going to be incredibly expeditious in this matter. We are going to be concluding the saga of LD 2150, which you will remember was an act to establish procedures for restricting access, state property, access to state services, and communication with or through state entities. Last we met on this amendment, there was the removal or not incorporation of the appropriations and allocation section. And then we came back and we're looking to put the language within existing resources in the text of the amendment. I struggled to find where that text should go based on what the fiscal note was purporting was the cost of that amendment. I spoke with our fiscal office, who went back and discussed with the Office of the Attorney General, who provided us, and I'm now providing you with a new fiscal note. The first section of that fiscal note, which pertained to the judicial branch, has remained the same. This bill may increase the number of civil suits filed in the court system. That's kind of the generic. This may increase the number of suits. What has been replaced is that second fiscal detail and note, which now reads, any additional costs to entities of the state to implement the provisions of this bill are expected to be minor and can be absorbed within existing budgeted resources. As a reminder, the members of that report are Senators Carney and Talbot Ross, Representatives Kuhn, Sinclair, Pugh, Henderson, Lee, Sato, and Caruso.
Thank you. Committee members, are there any questions? Comment, Representative Henderson?
No questions, but really good work, Eli. Thank you for following through on this.
All right, I'm not seeing any other questions. That looks good. Thank you. Are there any other items for the committee?
I'm now going to read from my extended works of, all set on my end.
That's for tomorrow, Eli. All right, can we have a motion to adjourn? All right, second, all in favor? All right, thank you, everyone.